Hello and welcome. Today, I'm going to be your guide to small claims court. We're going to be covering some basic considerations and questions about small claims court, and then we'll be talking to the person who's filing the lawsuit. You're called the plaintiff, how to do it. And then we're going to be talking to the person who's responding to the lawsuit. You're called the defendant. Finally, we'll be talking to both plaintiffs and defendants, how to make the best of your day in court. And then we're going to be talking about the decision you receive from the judge related to money, where you find out if you're a winning party or a losing party. This is called the judgment, how to understand it and how to react to it. And finally, we'll be talking to all the winning parties, which hopefully is all of you, how to collect your money. Many people think that the judge or the court will pay you once you win, but it's the losing party who pays you. Sometimes they do, sometimes they don't, and we'll talk about what to do if they don't. Before we begin, I just want to give you a disclosure that I am an attorney, but I'm not your attorney, as well as the attorneys that assist you in the self-help office of your local courthouse. All the information in this presentation is purely general information. It is not intended for your specific situation. There are many exceptions. You're probably wondering, are you even in the right room? Because you don't know what the small claims court is all about. Is it like any other court? The answer is no. Small claims is a very special court. The court that you are most familiar with is called Superior Court. That's where most parties will bring their dispute. That's what you think of with jury duty or in the movies. Small claims is unique in these ways. First, you have to ask the judge for money. Superior Court, you can ask the judge for an order. For example, ordering that you're no longer married to your spouse. And there's a maximum amount that you can ask for. As an individual, you can only ask for $7,500. If you're suing on behalf of your business, you can only ask for a maximum of $5,000. In Superior Court, you can ask for thousands, millions of dollars, assuming it's reasonable. Also, there's no attorneys allowed to represent you. This is a purpose of fairness, because this way, in Superior Court, where one side hires an attorney, the other side hires an attorney to have a level playing field. And it has a purpose of practicality, because the judge can talk directly to you, learn the story from your mouth, and not from someone else's. And because there are no attorneys, it's a lot less expensive. As you know, attorneys can be very expensive. Also, every time you turn in a form, there's a fee attached. This fee is a lot less in small claims versus Superior Court. The process is very quick. From start to finish, on average, most small claims are resolved within 3 months. The time that you stand before the judge, about 15 minutes long, and you receive your decision from the judge by mail within 10 to 12 days. Also, there's no jury. There's only one person who's going to judge your case, the judge, the only person you have to convince of your side of the story. And finally, both courts are ruled by the same rules of evidence and procedure, but the rules in small claims are a lot more simple and relaxed, mostly because there are no attorneys. So after comparing both courts, it kind of looks like small claims are a more attractive place to be, and that's why it's often referred to as the people's court. It's there to serve your needs as a person, not as a business. There's no weight of an attorney, jury, time, or costs to weigh you down. And in fact, it does have a very good reputation in our legal field as being very fair and very much in balance. Now, some of you may have looked at this picture and think that it looks unfair, it looks imbalanced, because you want your right to an attorney, you want your right to a jury. But if we added those constitutional safeguards to small claims court, it wouldn't be as fair and efficient as it is today. Now, perhaps this may be your first time before a judge, or your first impression of small claims court is that popular reality show called Judge Judy. And while there are many things you can learn from television, there are some important differences I want to point out. First, on TV, we always see the judge give the decision after the commercial, because as the audience, we don't want to wait any longer. But in your case, the judge will likely mail you the decision within 10 to 12 days. Also, we never see the same parties back in the next episode, and that's because the decision's final, also known as binding. But in your case, sometimes the decision can be appealed, and there can be a whole new hearing, and we will talk about when. Also, the reason we love to watch the television is because the judge yells at the parties interrupt each other. It's very dramatic. In your case, I can't promise it won't be dramatic, but it won't be as dramatic. And that's because the judge's role is to maintain respect in the courtroom, also known as decorum. And this is very important. On TV, we always see the person who's sued, called the defendant, show up in court. In your case, it's very likely the person you sue will not show up in court, simply because they don't want to come or they don't have proper notice. and we'll talk about the consequences of that as well. And finally, the reason people go on those television shows is because they know if they win, they can collect. That's because the producer pays the winning party. In your case, it's the losing party who will pay you. Again, sometimes they will, sometimes they won't, and we'll talk about what to do if they don't. So now we're going to talk about some basic considerations and questions. First question, who can sue? You can sue as long as you're an adult, you're mentally competent. Even if you're not from this country or you don't speak English, you have a right to sue. And any type of business can sue. But the most important thing is that in order to sue, you must be what's known as the real party in interest, which means it was you who was injured. If you receive a decision in your favor, you're going to receive the benefits of that decision. In other words, you can't sue on behalf of another. So if you are a person or business and you are the real party in interest and you file a lawsuit, you are called the plaintiff. Now, another basic question is, who can you sue or who can be sued? You can sue any person or business that lives in California. This is the general rule. Now, you can sue persons and businesses outside of California. There are exceptions. Generally, if that business has an office or physical facility in California, does business in California, or if that person had some sort of personal injury or property damage in California, owns real estate in California. There might be an issue with giving them service or giving them notice because notice must be within the state. Also, you can sue public entities, but first you must file a written claim with them first. They must reject it, then you can come to small claims court. So if you are a person or business or public entity and you're being sued by the plaintiff, you are called the defendant. Now, another basic question is, can someone else speak for you? Maybe you're nervous, or you think your husband or wife is more articulate, or you simply have a time conflict on the day of court. Well, unfortunately, the answer is no. The judge wants to talk to you and only you. No attorneys or non-attorneys can represent you. But with every general rule, there are a few exceptions, and these are the most common exceptions. For example, if you get in a car accident with your husband or wife, they suffer personal injuries and you do too, they can bring a suit on your behalf as well as their own. But make sure that you fill out the appropriate form, authorization to appear on behalf of party. This form can be found at your local courthouse at the small claims clerk's office. Now, before you actually go to court, we encourage you to try to informally solve your dispute because it'll be well worth your money, your time, and your effort. Some of these things you may have tried, some of you may have not, so let's go over them. The most informal thing you could do is ask the other party for money. Maybe they don't know that they owe you money. Or maybe you can't stand that party. You never want to talk to them again. Try talking to them through a neutral third party, such as an HOA association or a union. Something more formal is using mediation. We will talk about what mediation is next. Or trying to file a claim with the Department of Consumer Affairs or the Bureau of Automotive Repair. Something more formal is writing a demand letter. It doesn't have to be demanding, and we'll talk about how to write that next. And the most formal thing, of course, is going to small claims court, because what occurs there is decided by a judge, could affect your credit record, and becomes public record. Now, what it says in the cloud is that you should always write down your agreement if you come to agreement before you go to small claims court. What's in writing will always be more valuable to you in the future than what was said.